Welcome to Tax Sale Insiders, the latest from Tax Sale Resources, bringing you information about tax sales from experts in the industry. We interviewed Mark Manoyle of Manoyle Kime PLC based in Phoenix, Arizona. Mark's interest in the industry was piqued in college with a book called Acres for Cents, and he hasn't looked back since. Mark has been a member of the board of directors for the National Tax Lien Association and authored the book Arizona Property Tax Liens, Guide to Profit, Protection, and Prosecution. Mark shares his wide range of knowledge about the history of tax liens in Arizona and the current challenges to investors today. So sit back and relax for another episode of Tax Sale Insiders, powered by Tax Sale Resources.
Welcome, everybody, to this episode of Tax Sale Insiders. With me today, I have Mark Manoyle. Mark is one of the guys in Arizona. As we all know, there's not a ton of attorneys that know about tax liens or know tax liens real well in every state. And for those of you that are active or looking to get active in Arizona, Mark is certainly an amazing resource and blessed us with his time today. So thanks, Mark, for joining us.
I'm happy to be with you.
Mark, I'm trying to remember the first time we met. Mark and I hit it off at a National Tax Lien Association event several years ago, mainly because I went to school in the Phoenix area, and he's also in the Phoenix area. And so we got to commiserate over the miserable summers that seemed to happen in Phoenix. And then we were just talking about how you get the other end of the spectrum too. You don't have to shovel sunshine in Phoenix, do you?
No, and to be very topical, all the smoke that's being generated from California is supposedly flying over us and not coming into our breathing space. At least that's what they're telling us.
Well, when it's that hot, the smoke doesn't even want to come down to mess with that.
I think that's right.
Well, thanks for joining us, Mark. I've known you a long time, but not all of our listeners have. And so I guess I have two favorite questions. I ask one at the beginning and one at the end. But my favorite question is always, how did you land in this industry? Because most folks don't aspire to get in the tax liens, and so just out of curiosity, how long have you been in the industry? How did you get in the industry? Tell us a little bit about your background.
Well, I have to admit that throughout my grade school and high school and even college years, I did not aspire to be a lawyer practicing mainly in the property tax lien enforcement area. But when I got to law school, actually, that's when I took interest in it. And I've always heard that it's good to have, audio visual things when you're speaking. And so I'm going to show you a copy of the book that triggered my initial interest, Acres for Cents. And this was a scholarly book that a professor wrote about the role of property tax liens as a credit mechanism in frontier Iowa, which allowed investors, primarily from the East Coast, to get higher rates of return on their money than usury limitations would allow otherwise. And so farmers in Iowa would literally bet the farm by letting the taxes go unpaid, using their money to buy seed and hoping and praying that they could bring in a harvest, sell it, pay their back taxes with the accrued interest to save the farm and repeat the process next year. That triggered an interest in tax liens for me. And I went off on an independent study at that point while I was still in law school. And then, as many law students do, I had a summer clerkship with a law firm. And in the process of the summer clerkship, some actual real live tax lien investors came in as clients of the law firm, and I got to work on uh, their problem. And I hit it off with one of these investors, and so the lawyer who was supervising me kind of let me go, and I was transforming the theoretical that I'd been reading about in my independent study into a view of the practicality on the ground, and how this guy owned 20 lots in the subdivision, which was part of his legal issue that he'd obtained through tax lien. So all of a sudden, the theoretical became very real. And I'm sorry to talk so long about this bit of history, but this is what got me going. And I always found it interesting. I had a bit of a real estate background. I had a real estate agent's license and had done that before I even went to law school. So the tie-in to the real estate background and then seeing this kind of more technical legal area intrigued me. And so again, I didn't develop the interest in grade school, but actually pretty early on.
In school, not in grade school, but in school.
That's
awesome.
right.
I like your, you had a visual. I'll show my visual now. You wrote a great white paper.
Oh, thank you.
The process in Arizona for folks, and if they've read that, it's an excellent resource. So when I was reading that in my homework, I call it for our conversation. I've been in the industry for about 12 years. I do love one aspect of the industry is you learn something all the time, and every time I read a white paper, I learn something. And certainly learned an immense amount from yours, Mark. But one of the things I want to get into a little bit of I'll call it history or a little background of tax liens in Arizona. A lot of times the history of an area kind of forms how tax liens are treated today, and Arizona being the part of the Wild West, if you will. Is there any sort of that history in tax liens in Arizona?
Well, there sure is. I've been on a deep dive this summer reading about Arizona history with a real focus on this issue, and maybe you or your viewers will find interesting, as I did, that in the earliest days, Arizona came under United States jurisdiction after the Mexican-American War, the Treaty of Guadalupe Hidalgo in 1848, and then Arizona being cut off during the Civil War as a separate territory in 1863. That's when our kind of separate identity started. Mm-hmm. And all the same, the laws of the New Mexico Territory, which included Arizona, pretty much prevailed until statehood. The two states or two territories were on separate tracks after 1863. Mm-hmm. But one of the commonalities was that the county sheriff was appointed as not only a law enforcement officer, but the ex officio county assessor and tax collector. And so, and these were wide open ranges. This is before the days of telegraphs or trains. These county sheriffs had enormous spaces to cover. Mm-hmm. When Arizona was formed, it only had 4 counties, and they were gigantic. There's no way an individual, even with 1 or 2 assistants, could cover them. But there wasn't a lot of population, and and then settlement after the Civil War really started to happen fast. And to cut to the chase, in 1880 is when Cochise County, which is in the southeast corner of our state, was formed by the state legislature, and it was cut out of Pima County, which is where Tucson is the county seat, and which was one of the original 4 counties. So there was all this jockeying going on at the legislature about who would be appointed the first county officers of a brand new county called Cochise, and that's where Tombstone was. And if you know Tombstone, another name, Wyatt Earp,
Oh,
that goes right along with Tombstone. So had settled in Tombstone Brothers, as you've seen in the movies.
Oh, yeah.
And he was a contender wanting to be appointed county sheriff by the governor of the territory, who happened to be a Republican.
Okay.
And Wyatt Earp was a Republican. So he thought he might have a good shot at it. But southern Arizona had been settled by a lot of pro-slavery Anglos, and the governor appointed the other, Behan was his name, or Behan, I'm not sure how to pronounce it, and it may have been also that Wyatt Earp didn't have a real savory reputation because he had a gambling license, and had a bit of baggage from being a law enforcement officer in other places, but this kind of intrigued me. The county sheriffs were tax collectors, and part of their income was based on fees based on their collections. It was like contingent fees. So they had an incentive to go collect taxes.
Yeah.
It's a far cry from the system we're going to talk about today, but my deep dive into the history is all about the evolution of how Arizona's tax collection system has worked over the years, and then when it finally got adopted in roughly the form we are familiar with, which occurred more than 15 years after statehood. So,
Okay.
Up until then, the sheriff was doing his thing. Then they shifted the job to the treasurer. There were, the treasurer was authorized under territorial law to sell the property for taxes, with varying redemption rights. And then we finally got to the lien, or a different type of sale of the property, when the current system was adopted. Sorry, I got carried away. I love the history.
Fascinating. I love history too. It's crazy how Wyatt Earp, I grew up watching that movie all the time, Tombstone, and then Wyatt Earp with no, I'm gonna forget his name because I'm on camera. Kevin Costner, I guess he played Wyatt Earp, but
Yeah.
Interesting how it all kind of ties together. But yeah, Wyatt Earp didn't have the best reputation, a little bit of a heavy-handed sheriff.
Well, I have been thinking, maybe facetiously, about writing a short article for the Lawyers magazine about would Wyatt Earp really want to be county sheriff today if he didn't have the income from tax collection. That was one of the big drivers for people to serve as county sheriff back in the day.
Yeah, true. Well, I guess Arizona or Maricopa County has a history with an infamous sheriff, Joe Arpaio, as well. So you never know. It seems to run in the Arizona blood down there.
Maybe so.
Awesome. Well, you mentioned how where we ended up today. Part of your white paper kind of goes through how it's evolved over the last few decades. Anyway, what are some of the major changes you've seen through the last few decades from where it was, at least when you got into the industry?
Well, so I've been a perpetual student of the area, let's say, since I was in law school. And so that puts me back into the mid 1980s.
Okay.
It's hopefully older than some of your people watching this. And I started practicing law. I came out of law school in '88, but I really started working in this area around 1992. So for almost 30 years, I've been practicing law in the area. And one of the things that I noticed that has been a big change is the kind of respect for the tax lien from other governmental agencies. For the first 2 decades that I was working in this area, pretty close to 2 decades, the state attorney general's office, if there were other state claims of interest like tax liens or income tax liens, they would back off. We would name the state as a defendant, and they would stipulate to judgment in favor of our tax lien investor clients, and we would wipe out those other state liens.
Hmm.
Around 2010, with a new attorney general taking office, the policy position shifted, and I consider it kind of a pretty major shift for tax lien investors, where now, if there is a sales tax lien or an income tax lien, we get an answer from the attorney general's office saying you can't wipe us out, and your client will take title subject to our lien. And that, I think I wrote this in the white paper, this can turn a potential profitable investment into a negative one, where the tax lien investor pretty much has to walk away, not take on liabilities, rather than take on equity or take on profit. That's kind of the biggest, kind of harmful development that I've seen. And then, and that kind of fits under the rubric of priority, the super priority treatment of property tax liens, which is what attracts people to this area in the first place. And then, of course, you're familiar probably with the just drastic decrease in the interest rates that tax liens are being sold at. And that's kind of a function of a more marketplace created by the internet-based tax auctions. There's more competition. People are driving interest rates way down, and now it's not uncommon to see 0% bid on tax liens, where people are betting on foreclosure and giving up on earning interest from their tax liens. And foreclosure just doesn't happen that much, except in certain categories of properties, like raw land.
Right. Interesting. The more different states I talk to, and the changes, as I typically ask that question of everybody, what's changed, recently, and there seems to be some commonality right around 2010 of either a complete change in their process overall in the last 10 years, or more and more challenges to the superiority of that tax lien across the board. So it's definitely I don't know if it's driven by increase in competition. There's just a lot more investors. So, like you said, the state attorney general may feel more comfortable saying no, because they know 50 years ago, right? There was not many investors in the realm. You tell one investor no, all of a sudden there's no income for that county. And now, that's a theory, but now with more and more investors involved, and that's a downside of that. Another downside of that competition is you have more risks to that superiority. Interesting. Well, let's get to the basics, if you will, and just talk about how the process works in Arizona, today. Real basic is, do you consider Arizona a lien state or a redeemable deed state, or a combination?
Well, I think today it's clearly a lien state. I was tempted to say, but prior to 1984, it was a redeemable deed state. In that year, in 1984, the legislature amended all of the property tax enforcement statutes to say that a lien was being sold, and inserting that language into statutes that previously said that the property is being sold for the taxes. And that's how most people colloquially refer to this area, as property going up for taxes or being sold for taxes. 1984, they made it clear. And the redemption features didn't really change much, but the vocabulary should have changed. We still use the word redeem to mean paying off the back taxes, but redeem really means to buy back, or to recover from sale of property. And in this case, property hasn't actually been sold, just a lien has been sold. So it's properly satisfaction of the lien when you pay it off, than redeeming it. But that's the term used in our state, in our statutes and common.
Got it. So
legal parlance.
So anybody that buys a certificate or a lien really has no rights to the property, right? You have interest in the property at that point, just like any
That's right. No possessory rights, no right to enter or anything like that.
Got it. Okay. Now, you've hinted at this a little bit, how some of the auctions have gone online, but can you describe more about, how are the auctions conducted? Are they all live, are they all online these days, or, and how is the bid done? I'm assuming it's a bid down in interest. Is there any minimum penalty? I'll use Florida as an example. People bid down to 0 or 1/4%, I guess, is the common bid in Arizona, because they know they have that 5% penalty that they're going to get. Does anything like that exist in Arizona?
Unfortunately, no. So you're stuck with what you get, and again, in terms of adverse developments over the recent years, statute clarifying when the interest starts to run was amended just a few years ago to say that statute's computed on a monthly basis, not a daily basis. So you earn interest for each new month or portion of a month, assuming the lien gets redeemed in the middle of the month, you get that month's interest.
Mm-hmm.
It used to be the computation started when you bought the lien. So it was possible, if you bought the lien at auction in February, to earn a portion of a month's interest in the month of February if somebody redeemed the tax lien, say by February 28th or February 29th. Well, they clarified it in this recent amendment to say it starts the next month after you buy it. So because interest is baked into your purchase price, whether you buy it at auction or you buy it from the treasurer's office, and the interest only starts to accrue the following month.
Got it. So you go to the auction, you bid it down to 8% per se, which is probably high. It's probably well below 5 on average in Arizona these days, but you bid it down to 4% and you have that certificate. If somebody goes and redeems that before the end of the month, you get that money back, but you're out whatever you spent in your research and due diligence in purchasing that lien, right? Because you get zero.
Yeah, well put. Those are, often people don't quantify or value their time, and they really have to. And that's all part of the investment. But there is an actual out-of-pocket fee that's paid that's not reimbursed on redemption. So just from the straight dollars in, dollars out point of view, you get back less than you put in that scenario you just described.
Okay, so the fee that you pay to take that assignment or that lien on, you don't get that back either. Interesting. Right. Okay, now as far as the auctions, live versus online, or I know Maricopa's online, is how many? There's 16 counties in Arizona, I believe.
15 counties, and I think 7 or 8 of them, about half, are online. And they don't break, and I think that the trend is for more, especially with the pandemic. They're not going to want to have an auditorium full of people, for these things. So I predict that pretty much will all be online this coming February. The auctions always occur in the month of February in Arizona. Even with elections of county treasurers happening right now, I think they need to be preparing to go online. We have a couple of small counties where they never have very many. They may persist as live call auctions, but up to now, Maricopa has been online more than 10 years. Pima has up to this point been live call and resisted going to the internet. Pima is the second largest county. And then we have a mixture, really regardless of size, of ones that have gone to the internet and others that not. For instance, Yavapai, Coconino County, and even I think Apache and Navajo all have online auctions. Mojave is online, but I think Yuma County has stayed with the live call. They may be shifting over soon. And then Gila, Graham, Greenlee, Cochise, those are all live call counties that will probably need to move to internet-based auctions.
So it'll be interesting to see how Arizona plays out, because that's one of the things that we, from a data standpoint, notice is the rates of return in live auctions typically are a little better. So with more and more auctions going online, it'll be interesting to see how if Arizona follows that trend, how the Arizona average winning bid amount may I guess expected to be going down next year if that's what happens.
Right.
What happens to the liens that don't sell at auction? Do they just roll over to the next auction? Can you buy them directly from the county and I call over-the-counter situation, or what happens to those?
Well put question. You used the term of art, over the counter. Yes, they become available, and the treasurer's authorized to sell them to the first person who shows up willing to pay for them, and they get the 16% interest, which is the highest rate of interest available because there's no bidding on them. It's just you get it. With the internet auctions, I think that the auctioneers are actually having a follow-up auction where there is bidding, and so they're still trying to sell liens. There are some cases where people bid and then don't follow through and pay the money to get the lien, so it needs to be reoffered. So they have like a bump or second auction. But even when all those efforts are exhausted, the liens are supposed to be available if they haven't been purchased right at the treasurer's office. And sometimes you can pick up good things there, and at 16%. So if you know something nobody else knows, you can benefit.
Got it. So if you do your research, obviously, but there's still some gems in there you can find after the auction, and it's just a first come first served basis. That's how they operate.
Yes, historically, before the internet auctions, really, there used to be a line that formed the night before that counter opened at Maricopa County Treasurer's Office. Mm-hmm. The line would start forming around 11 p.m. the night before, and people would spend the night building the line. They would camp out. They would do things in shifts to not lose their place. And it was kind of notorious among tax lien investors what you had to do if you wanted to get into something that had been missed at auction. But again, it's that more perfect marketplace of auctions. More stuff is getting cleared out, so the enthusiasm for spending the night outside in the wintertime has been lessened a little bit.
Yeah, I didn't even realize that's what it used to be in Arizona. It's kind of funny. I'm originally from Montana, so we follow the sales there fairly closely, and it's still kind of Wild West in Montana with how they do their auctions, because it's still they have an auction date per se, but it's still a first come first serve. Whoever comes in the door, at 8:30 or 9 o'clock in the morning, whenever they open the doors, you get every lien that's on your list. So basically, whoever's in first with the most capital could buy every good lien. It's kind of crazy. But the fact that and there's a lot of pressure there to change their process, but it's entertaining to see that Arizona was doing that several decades ago, and Montana's doing it now. So we're just Montana's just behind the trend as usual.
Well, there's I think you might be asking me about it, but Montana's ahead of us in terms of new law adoption. I think a couple of years ago, I actually attended a Montana County Treasurers Conference about a year ago as they discussed the implementation of this new law. Same people backing that law are trying to push something similar down here. There actually is quite a bit of difference between how Montana and Arizona works in terms of the enforcement side, and they're trying to run with their great success of legislative adoption in Montana to Arizona. This at the beginning of this year, they pushed their bill. We managed to oppose it. I worked with the county treasurers on that project, but I suspect the contest is not over yet, and they may be back. That may be something new, a new hurdle to deal with this coming legislative session.
That's one of the potential changes coming down the pipeline in Arizona that's been put on hold, but not totally dead yet. Is that right?
Yeah, the way of putting it.
Interesting. Right. Interesting. Now, we talked about the interest already, but there's this, you call it sale and error in your paper. One of the things that I learned from your white paper, Mark, the only other state I've ever seen that term used in is in Illinois. And in Illinois, it's almost like this insurance policy of if something happens to the property or if a lien ends up the property doesn't end up being in the same state at the end of the life cycle as it was at the beginning. There's all these opportunities for the investor to get their money back, which is almost unheard of in the lien industry. But you mentioned in Arizona, so explain to me what the sale and error process is in Arizona.
Well, it's much, much narrower in application here than in Illinois. I'm licensed in Illinois, and I'm familiar with their thing, which is sort of like a duo statute, for the investor or the property owner with the investor's cooperation can just kind of undo the tax lien purchase, long after it occurs. And in Arizona, the sale and error statute is limited by its own language. It says to when taxes were not due. So you pretty much have to be approaching the Board of Supervisors here, or the the county treasurer, with a situation where the taxes had already been paid or the property was exempt from taxation. I can't really think of a whole lot of other opportunities for the taxes not to be due. And usually you get a big no when you apply for that. There is an alternative path, though, that it's actually two alternatives, depending on which officer you go to, and it's called lien abatement. And both the Board of Supervisors as the executive body and the county treasurer have certain limited authority to abate the back taxes if they make certain findings, like the property would not sell for the total amount of taxes, interest, and penalties. They have the statutory authority to write down the taxes or eliminate them. And again, something that's infrequently employed, but I've used it on behalf of clients before, both property owner clients who were trying to avoid big tax liens that really weren't justified because the valuation was screwed up on the underlying property, like common area elements in housing development, or investors who found out that their lien was on a strip that was alongside a road, and they could make a persuasive argument that that strip was actually being used as part of the roadway, and even though it wasn't titled in the state or county government, it was essentially being used that way as for they get the amount of money on that kind of
Interesting. So it's similar in use, but not much more narrow in scope as far as what you.
Yeah, it's not easy. It's when I did it each time, the process took more than a year.
Got it. Okay.
Yeah.
So if you're coming from Illinois and you see that sale and error verbiage, don't assume you got that same insurance policy like you do in Illinois.
Right.
Interesting. But I'm gonna get back to the basics again as far as redemption goes in Arizona. So how long is the redemption period in Arizona?
Well, technically, the delinquent property owner has a right to redeem until a judgment is entered foreclosing that right to redeem.
Okay.
But the statute says 3 years. And 3 years is when the tax lien investor may commence the tax lien foreclosure action, which is a judicial foreclosure. So even after the 3 years has passed, during the pendency of the foreclosure action, at any time, the property owner or any other interested party can still redeem the tax lien if a judge hasn't entered a judgment saying your right to redeem is foreclosed and you no longer have an interest in the property.
Got it. Okay. So it's not necessarily the redemption from the owner's perspective is longer than 3 years, but as far as the time between you buy the lien and you can start the foreclosure, that's 3 years. Is there anything that's required during that redemption period? Notifications, filings, anything like that in that time period?
Sure. Well, we're talking about the basic enforcement procedure, and that is that at least 30 days before the foreclosure suit is commenced, our law requires that a notice be sent. We call it the 30-day notice.
Okay.
And it has to be certified mail to the addresses of record in the treasurer's and assessor's records. There's an alternative where you can send it to the owner of record, but then you're sort of passing a title examination judgment on who the actual owner of record is. The assessor's and treasurer's requirement is a very blind requirement. It's easy to comply with, and most of the time that's how notices are given. It's by certified mail with a certified mail copy to the county treasurer. You wait a notice period, and assuming it falls, the 30th day falls after the 3-year anniversary of when the lien was purchased, that's when that 3-year time frame starts. The suit can be filed, and it's a civil suit in Superior Court in county property is located. And like any other civil suit, before filing, we will get a title report that indicates who the interested parties are. Besides the owner of record, there may be judgment lien holders and mortgage holders and other lien claimants, and those people or parties all be added as other defendants, and then we have to find them and able to serve them with a sentencing complaint in that lawsuit. We have under Arizona law, if they're in Arizona, they have 20 days to respond. If they're outside of Arizona, they have 30 days, and governmental and insurance company entities have a little more time to respond. But if they don't respond within those times, then the next step is for us to file an application for default against them for having failed to respond. And under our rules of court procedure, they're given yet another 2 weeks to still respond and have it be considered timely. So after that 2-week period has expired, then the court can hear a default judgment hearing, and we usually have to schedule it, and it may not be immediate, but assuming that answer never comes in, then we go to court and get a default judgment, and the judgment is one that orders the treasurer to issue a deed to the tax lien investor. And I'll just anticipate a question that you might have. If the tax lien is redeemed during the pendency of the litigation and redeemed by a person who's been served in the action, then that person is liable under the statute for the costs of the investor, including reasonable attorney's fees.
Okay.
And
plus interest at all, or just
I'm sorry?
Plus interest at all?
No.
Okay.
No. Well, not at that point.
Okay.
If it's not voluntarily paid by the party who voluntarily redeemed, which often it is, then the case is actually continued, but just to get a money judgment for those legal expenses. And then there's a judgment issued saying, redeeming party, you owe tax lien investor X dollars for fees and Y dollars for costs. And when that and usually it provides for interest on the judgment, and the judgment's recorded, and then you are earning interest on fees and costs post-judgment, but not during the pendency of the action if it's redeemed.
Got it. Okay. So how long does that process? I know it varies across the board. It's a lawsuit, right? It can be very long, but in general, how long does that process typically take from, the end of that 30-day notice, so the start or the end of the 3 years, right, till you get the judgment?
Well, we've had it done as fast as 2 months from filing the lawsuit to judgment, which is our land speed record in our office. It's usually not anywhere that fast. It's usually, I tell clients 4 to 6 months, but as you note, if you have a case with lots of defendants and of whom are difficult to serve, it can take you more than a year. You may have to resort to by publication, which by itself adds a month to the process. Or you may just be choosing somebody who is owing or trying different locations that your investment value will be, and you go to court because you actually have a limited time in which to serve all the defendants. It's 90 days under court rules, which is kind of a short period, but the courts are liberal about extending that if you show you're making an effort. And so go and you say, well, we tried 3 different addresses and 5 times each address, and we can't find the person yet. We need more time. They'll be another 60 or 90 days, and they'll do it a couple of times if necessary. So that's the biggest driver of how long it takes. Once the search is done, assuming nobody files an answer to draft positive motions, like a motion for some judgment or a motion for judgment on the pleadings, those things themselves, as they require responses from the other side and then reply briefs, sort of the thing really expand the time it takes to resolve. But if it goes by default, the 6 months thing is usually pretty accurate.
Okay, so 6 months and then to get a judgment, and then what is there any step required after that judgment to obtain ownership? Like, do they say here's a deed, but you're responsible for recording it or anything like that?
Yeah, good question. So you get a judgment that says all these parties' right to redeem is foreclosed, and that by itself is kind of like a quiet title judgment that says, this person has the rights and all people have no rights in the property. But statute provides that the judgment is to order the county treasurer issue a treasurer's deed. So it's a ministerial act by the treasurer that completes the process. You present a certified copy of the judgment to the treasurer, and depending on what time of year it is, and I'm not saying that facetiously, I'm saying that with reference to whether it's tax bill issuing time or tax payment deadline time. Those are the times of year that can delay them working on tax deeds.
Right.
It'll take them a week or 2 usually to issue the treasurer's deed, and then it is up to the investor or counsel for the investor to record that deed, and that's when you have title. That's when you own it.
Okay.
Your question, I think, may have also kind of implied possession if it's property, and you not be done yet. If part of you foreclosed on is in the property, then you may have to do some kind of eviction work. There is a provision in the normal foreclosure of mortgages context for getting a writ of restitution after doing a mortgage foreclosure. I think that could be applied in the tax lien context, but more commonly, we take the file and pass it to somebody who does eviction work only, and they do a separate eviction action if necessary, on inhabited, improved property.
Okay. Well, now, how long does that ejection eviction process and every state's different? How long does that typically take in Arizona?
It moves very quickly. It's a prioritized action, so 2 to 4 weeks usually.
Okay, so another month or so. Okay.
And then and the result of it is a judgment for a right of possession and an issuance of a writ that the sheriff or a constable will go out and serve, and they will supervise the moving out of the person or party that's in the property.
Got it. Interesting. Okay. What at the end of all this process, you have a treasurer's deed, right? Is that insurable title with that treasurer's deed, or do you now have to go get quiet title in order to get insurable title?
Well, a good question, Brian. You have been touching bases all over the country, so this is a big issue. A few years back, I think partly due to sloppy lawyering by other lawyers, not me, of course, title insurance companies were paying out claims for failure of title because the underlying tax lien foreclosures had not been done very well, and they missed interested parties who wanted to protect their interest, and ultimately said, hey, you're telling me I got foreclosed? No way. And they would come in and set aside the judgment. They would file motions have their arguments, ultimately get a new judgment setting aside the prior foreclosure judgment, and that would kill the deed. It would nullify it. And at that point, if the property had been sold from the original foreclosing investor, the title company was left holding the bag. They would have to pay out on their insurance policy. So a lot of the title insurance industry said, this business of insuring treasurer's deeds or back tax deeds, if you will, is just not worth it. We're going to stop doing it. And some of the major underwriters, the Fidelity, Chicago Title family of title insurers, said no more. First American Title, no more. So the biggest insurance companies don't like treasurer's deeds and don't want to insure them. Mm-hmm. We have working relationships with other title underwriters, and they will request to see parts of the court file to assure themselves that the major areas of risk for a judgment being set aside have been addressed. Mm-hmm. And if they reach a comfort level, then they will insure. And I don't know of any of my cases where where they've refused to insure, but there are, so there are some players in the title insurance space that will insure straight away without the standard, go do a quiet title action, which is actually very redundant with the title tax lien foreclosure work that we do, because we're serving by publication. We're doing all the same things that a quiet title action would require. Mm-hmm. But you're familiar with some of the other vendors who are out there supporting tax lien investors who get deeds that come out of administrative processes. And some of those folks, those same insurance companies, will do their own examination, and they will insure too if it's a little shakier or not the same company I deal with, for instance.
Got it. So like a title certification, I call it.
Yes.
From those services. Now, right. Let me make sure I got this right. So if the treasurer's deed comes with the stamp of approval from essentially Mark Manoyle, because Mark Manoyle did the work on it, then there are insurance companies that you work with that say, okay, Mark did this, we're comfortable with it, you don't have to do anything more, we'll issue title insurance on it.
Right.
But if you work with, and there might be similar instances with other attorneys, but there's also, if it's an attorney that isn't familiar with the industry and never done this before, chances are, that same title insurance company will get that file and say, okay, we're not going to issue title insurance on this because we're just not as familiar with, to make sure that you did everything right. We're going to make you go through a quiet title action in order to get title insurance. Is that accurate?
That's pretty fair.
Okay.
Fair state. Yeah.
Now, if you do have to go through a quiet title action, how long does that process typically take in Arizona?
It's a very, very similar process to the foreclosure.
There's 6 months.
And it starts, instead of with a 30-day notice, it starts with a 20-day demand letter with a quitclaim deed and a $5 check. And you identify the parties who supposedly have a claim of record that you want to extinguish, and you send them a letter saying, please sign the quitclaim deed and send it back to me, and here's your $5 check. And if they refuse, then you have statutorily set the hook for legal expense liability on them. That's the purpose of that notice. You can file a quiet title suit straight away, but at your own expense, unless you do that first step I mentioned. So the quiet title suit, to answer your question, again, same kind of time frame. I'd say maybe 4 to 8 months, depending on court's calendar. But you're looking at serving all the parties that supposedly have an arguable claim of interest or a cloud on the title that you're trying to eliminate. And then the summons is essentially saying, come to court and defend your claim of interest, and we're going to oppose it, and we're going to have the judge decide whether your interest survives or not. And most people, ignore it, let it go by default, or stipulate to judgment unless they really do contest the title or want to preserve their interest. Like, no, my interest survived because you didn't serve me in your tax foreclosure action, that would probably be a legitimate defense for somebody.
Got it. Interesting. Okay. Now, does any of this process vary, or is it expedited for any reason, for like because of the type of property, or that it's vacant versus occupied? Does anything like that exist in Arizona?
No, I touched on history a little bit, but you and your audience should probably know that our law is pretty much the same law that was adopted in 1929. And they have not introduced those kinds of distinctions into it since then.
Okay.
So it's the same whether it's a piece of rural unimproved land or a commercial office building in downtown Phoenix. Same process, same time frames and everything.
Okay.
Yeah.
All right. So as far as timeline goes, roughly 3 years to start the process. Then let's say, between 7 and 8 months after that, assuming all goes as normal, you would have a treasurer's deed in hand. And if it was done by you, Mark, then you would also be able to close with title insurance at that point. Now, do investors have to start the judgment at 3 years, or can they wait till 5 years, or do liens ever expire?
They do expire, but it's a pretty generous, let's call it a statute of limitations. It's 10 years from the date of acquisition.
Oh, wow.
So, you buy at the February 2020 auction, your lien will officially evaporate if you don't do anything with it March 1st of 2030.
Okay.
So it's a good long time.
Okay. You have to start your judgment by that date, or you have to be done and have a treasurer's deed in hand at that 10 years?
Again, just start.
Okay.
So it could be as minimal as just sending that 30-day notice before that date, even if the lawsuit isn't filed yet.
Got it. Okay. Now, are there any liens, or fines is probably a better name for it, that kind of stick to the deed throughout this foreclosure process? Because one of the biggest assumptions with tax liens is that all other liens are wiped out, and that's not necessarily the case.
Right.
In most states. The big ones that most people worry about, mortgages, I'm assuming, are wiped out. But are there any other liens, IRS liens, for example, or HOA liens, or in the fine category, more code violations that survive that foreclosure process?
So yes is the answer. To be more specific, there is a mechanism under the federal treasury regulations that allows us to treat the tax lien foreclosure like a mortgage foreclosure for purposes of extinguishing a federal tax lien. So that can be done, but that procedure has to be followed, and it's not in state statute, it's under the federal regulations in terms of the giving of a notice to the IRS in advance, a certain time in advance of the ultimate foreclosure judgment hearing. I mentioned earlier in our conversation the priority challenges that have started to evolve or come out of the Attorney General's office with sales tax liens and income tax liens. So those are a threat. There's also healthcare related liens under the Medicaid law, where there's specific authorization under the federal law to record a lien of paramount priority against the property. And for now, the way our clients are dealing with those when they run into them is essentially working out a settlement and in some sense on dollar with the local authority that manages those government liens. HOA liens do get scraped off in tax lien foreclosure, and I'll confirm mortgages and money judgment liens held by private parties also get scraped off. So it really comes back to other governmental entities trying to preserve their lien claims. Nuisance abatement liens, which you referred to as far as like other city claims, historically have been scraped off, but there is a trend among some of the cities in the state to try to oppose that and say, no, we're protected. And I don't think the jury is completely in on that. I litigated this quite a bit last year, not successfully, but I think in the course of doing it, I discovered my best arguments too late in the game. And so I still kind of think that tax lien has priority over the nuisance abatement liens for things like board up or demolition or cutting grass, those kinds of things that cities do.
Got it. So it's still, I guess, undecided, but still you believe that there's still good arguments for why those are wiped out.
Yes.
Got it. Interesting. Okay. What, the Arizona process, I guess, during redemption is a little less complicated than some other states that I've learned about in recent months. So where do attorneys typically get involved in the process? Is it at that 30-day notice? Is it at the beginning during due diligence, or like when do investors typically reach out to you for help?
I prefer not to exercise business judgment on behalf of my clients or be an investment advisor. Mm-hmm. So in my case, I'm usually only hearing from them when their liens are approaching that 3-year anniversary and they're going to become foreclosable. Okay. And again, they may get redeemed, so it's kind of in the client's interest not to involve me in their life until it looks like this lien is going to need to be enforced because it's not going to take care of itself. I think some other lawyers may take a more active role, though, along the lines you were describing, where they're holding the hand of their investor client and giving them feedback on due diligence about the property or the parties with an interest in the property. They may do some advanced research about it. So I would say I'm not necessarily representative of other lawyers who do this work.
Got it. Okay. But if they want to work with you, Mark, then we reach out around that 30-day notice mark, a few months before the end of that 3-year period.
I don't like to give legal advice. I'm trying to treat this as informational, but I'll just say that with my clients, I encourage them to send out that 30-day notice actually 90 days or more before the maturity date. Okay. 30 days back from, say, a mid-February anniversary date would put you in the middle of January, right? I actually encourage my clients to send out the notices in November, the prior November, to try to encourage the redemption if it's going to happen based on that mailed notice, so that the money flows back to my clients and they have it for the next auction and they can redeploy it. If we wait till the end of January or wait until the 3 years has completely passed before we do the notice, then the auction will have probably already occurred. Right. And they're getting their money back and then trying to find a new place to put it if they are, if they want to reinvest it. So
excellent tip. Well, thank you for that. A couple other kind of, I'll say random questions, but certainly helps us kind of paint a better picture on Arizona as a whole. But would you consider Arizona's process to be fairly static at this point, or is it, do you foresee a lot of changes come down the pipeline, and I guess more dynamic, I guess would be the other term. Where do you see?
Yeah. It's kind of a sensibility question, and I actually, well, like I said, I've been practicing in the area for almost 30 years, but I also, as part of my professional identity, I participate in legislative activity around this area. It may be making proposals for reform ideas that I think kind of strengthen or lead to making it more stable and predictable in terms of outcomes for investors, or the role may involve playing defense against what I consider bad ideas, or at least commenting and complaining about laws that get passed that I was unaware of being pending. I'm not a lobbyist, so I don't have full time to spend on legislature when it's in session. But we've had a heck of a lot of lawmaking and amending going on in the last 5 or 6 years, and and some court decisions that also affect this area. And so from my point of view, it's a very dynamic area, and that would lead me to just kind of caution potential investors or current investors that they have to realize, as a former Maricopa County Treasurer Doug Todd used to say, you're playing a game where the government makes the rules and can change the rules, and if you don't like the game, don't play. I kind of took offense at that a little bit. I thought, well, that's kind of an arrogant position, but it's a statement of fact.
Yeah.
And unfortunately, he was right. He was a good treasurer from my point of view, but in these last few years, we've seen developments like a set of laws be adopted that applies only in Maricopa County. Half a dozen laws that are specific to Maricopa County and separate it from all the other 14 counties, so that another caution, don't think that your understanding of how things work in one county necessarily translates to other counties. You have to sort of go through the learning curve in each new county where you invest, to make sure that you understand how they do it, because there are local variations in things that you would think are not really open to diverse interpretations.
Yeah, it's interesting because you see that, I've seen that or heard of it in multiple states now, where the big metro areas adopt a slightly different rule set as opposed to the rest of the state. You see that in Illinois with Cook County, and
sure.
In Missouri, I talked to a gentleman and he was explaining how the two major metro areas in Missouri each has their own slightly different rules. So as that population seems to grow, that's when they decide, okay, we need to play by different rules for one reason or another. So it's interesting.
Well, I'm sorry, may I pursue that point with you for just a little bit more? Well, the Maricopa County is almost 2/3 of the population and the wealth of the state. And so the county treasurer, or county treasurer's office, I should say, sort of has outsized weight at the legislature. And when it's politicized, as I think it has been for at least the last 4 or 5 years, it can drive some kind of bad results, which is what happened. And the half dozen laws for Maricopa County, I think, really create some disincentives for tax investors in Maricopa County. And part of it, I think, is tied to the ideology of the incumbents during this period. Part of it may be ascribed to their ignorance about how the system actually works or is designed to work. May just be open hostility to that. And I want to give you an example for your audience too. In Maricopa County, one of these laws required that every tax year be sold as a separate tax certificate, rather than the existing practice, which remains in the other counties, where if you buy a tax lien, you have the first right to add on the next delinquent year to the certificate, endorse additional taxes, you pay the extra money, the next year's taxes, and the treasurer adds that to your tax certificate. And so during that 3-year hold time, you're paying additional year's taxes, right?
Right.
So at the end of the 3-year period, you have a tax lien that has 3 or 4 years of taxes on it. And that's what you go to the foreclosure action with. Well, in Maricopa County, because each year is mandated to be a separate certificate, means that the foreclosability of each year is tied to the sale date of that separate certificate. So if you buy a lien in February, you can you have the first right to buy the next certificate. You still have that subtax right, if you will,
Right.
which arises June 1st. You can buy the next delinquent year, but it's a separate certificate. So because it's a separate certificate, that means that second delinquent year won't be foreclosable until 3 years from that date that you paid for that. So it won't go to the February date. You have to wait until 3 years has passed on the second one for both of them to have become foreclosable. And likewise, if you buy another delinquent year a year later in June the following year, you're going to have to wait for 3 years from that for all three of your years to be foreclosable at the same time. So by only being able to, if you want to foreclose as soon as possible, which I would think the public policy would actually favor, because you want to return the properties to the active role, either by getting them current on their back taxes or changing the ownership to somebody who will pay the taxes. They have actually gone in the other direction by giving you an incentive to wait longer to start your foreclosure action, or engage in a kicking the can down the road operation where you've constantly are financing the back taxes for the delinquent property owner, but only able to bring action to enforce, a portion of what you've paid out in the back taxes. If you go off the 3 year dates, it just doesn't make sense to me as being sensible.
Yeah. So when you file that, you start the foreclosure process. Part of that process, I was assuming, and maybe wrongfully so, you would have to bring all the other taxes current, right? So you're kind of self-redeeming in that.
In some counties, that is the rule.
Okay.
Before this separate set of laws for Maricopa County, there were two modes of operation, and it's probably good that we discuss this so people can ask which is it when they go to any given county. But there's a statute that authorizes the county treasurers to require people to essentially pay their subtax, pay the next delinquency, and service the lien, essentially.
Right.
And the consequence, if they fail to do so, is that the lien that has already been sold will be reoffered to somebody else at the next delinquency auction, and it will be rolled up into a new lien. It's that later year delinquency,
right?
And so there will only be one tax lien holder on a parcel at a time in that group of counties that require that.
Got it.
The other system, which has included Maricopa and Pima counties, and more recently Pinal and Yavapai counties, says that we don't care how many certificate holders there are, you're not required to subtax. You can buy 1 year and sit on it, and when the next delinquency arises, we'll sell that to somebody else. And so they don't require there to be just one certificate holder. I frankly find that sort of a fertile ground for duplicative expenses, because you can potentially get to a point where you have multiple parties foreclosing liens, their different year liens at the same time.
Right.
And then it becomes a Texas shootout for whoever succeeds in foreclosing first has to pay off not just the other tax years, but also has to pay the legal fees for anybody who's filed a foreclosure suit on those other years. So it's a messier situation full of gamesmanship. And in the counties where they require just one holder, that's all avoided,
Right.
So it's a little cleaner.
Got it. So you do in both cases, sounds like it's more when you get the final judgment. Part of that final judgment is you have to pay all other open taxes.
Yeah, well, in some counties it's more mandated or required to get the treasurer's deed, say, than in others. In Maricopa County, for instance, you can get a judgment on a 1 year tax lien position, and when they give you your treasurer's deed, they will also give you a tax statement showing all the other outstanding back taxes, and they'll kind of gently say, you know, you might want to
Congratulations.
pay off these other back taxes before they foreclose on you,
Right.
because that's the next thing that's going to happen.
Got it.
In other counties, like I think Mojave County, my experience has been that the judge will not permit the foreclosure if you haven't paid all the subsequent delinquent taxes and added them onto your tax certificate. So you have to get it done even before you can get the judgment. So again, county by county type of deal.
So what's the right question to ask? You know, county by county. Is this a county that allows subs or not? Is that kind of the question?
Um, you know, I'm amused that you asked the question, because I have actually asked the question, but I didn't use the right words and I didn't get the right answer.
Oh. All right.
I was aware of this issue once, and I thought I was asking the question to get the right answer to this question. And the person misunderstood me, and they used a different vocabulary inside the treasurer's office than what I used in my question, and I got the wrong answer.
Uh-huh.
And I was concerned, because I was in the process of a tax foreclosure for a client who had not subtaxed, and I knew that subtax was going to be going to the next February auction, and we were really close. Our lawsuit was pending. We weren't going to be done with it.
Right.
The tax auction was coming up, and so I called the treasurer's office and I said, are you going to reassign my client's tax lien based on whoever buys at this auction? And because their vocabulary was something like redeem and reissue rather than reassign, they said, oh no. So essentially they did reassign my client's position to the new buyer. And that's effectively pulling the rug out from under our tax foreclosure suit, because the client I represented no longer owned the tax lien. And so I don't want to suggest the right words, because I may be wrong.
Yeah, the vocabulary changes by county. Is that
the question needs to probably be asked several times in several different ways to make sure you have a higher confidence level in the answer.
Interesting. Yeah. We deal with that, talking to counties across the country and just asking the same question different ways to different people. You can get wildly different answers. It's kind of crazy.
This is why we're students more than teachers.
Yeah. Yeah, it's crazy, isn't it? All right, so it's fairly dynamic, environment. It sounds like it's becoming more and more politicized, which quite honestly is kind of sad to see, because in some ways it doesn't always bode well for either investors or homeowners. It just ends up being whatever the political party deems is most beneficial to them at that point in time. But that in mind, I guess, is there any other major changes coming down the pipeline in Arizona that you foresee that would change things drastically?
Well, if this group that pushed the Montana law that we talked about succeeds in their goals here, they will effectively completely eliminate the incentive to buy tax liens in Arizona, because what they propose so far, at least, is that tax lien investors buy the tax lien, hire me or another lawyer to foreclose it, but for the benefit of the county treasurer to then have an auction of the property. And presumably, I guess, even though they didn't think this was a necessary part of their proposal, at that point, after the sale, the investor would get their money back with some interest, and maybe get their legal fees covered. They were very vague about those details, which would be critical to the investor.
Right.
But then they went on in great detail about finder's fees, people helping equity claimants on the pool of funds generated from the sales to make their claims. And that was kind of their focus, was we want to have sheriff sales instead of quiet title outcomes for tax lien foreclosures. And we want the sheriff sales to benefit all the parties who got foreclosed, not to benefit the investor who did the heavy lifting of bringing the foreclosure action.
Got it. Interesting. It definitely would change the environment entirely, like you said. Sounds like it's closest state I can think of is Florida, where they have that secondary tax deduction at the end. But they haven't defined what kind of interest would be associated with it, and would at least benefit the investor that bought the lien in the first place. All that is very unknown.
Well, in the Florida situation, I'm sure you're much better informed than I am. The original investor who bought the tax lien, doesn't really have to do much more than make an application to the clerk of the court or something like that.
Yeah.
And that's when that next sale event occurs, right?
Right.
But they don't have to mount a lawsuit and go out and find people and serve them and take on all those risks of litigation. And that's kind of my point is, this is not a frictionless system that's self-executing. It requires some labor,
Right. And there's significant cost to doing that, right? And there's no interest involved in that. So the only incentive in doing that right now is the potential of having the property at the end of the day, right?
Well, yeah, I think so. I think that's the main driver for people to participate.
Interesting. Well, it certainly doesn't seem to be a change that would bode well for at least the current environment in Arizona. I'm sure you're watching it very, very closely to see what they try, and I'm sure NTLA is all over it.
I will mention one other thing, because this is actually an idea that I proposed to the county treasurers, and I think they are going to push it in the next legislative session as part of their own legislative agenda. That is that we have a 24, next year will be a 25-year-old law on the books that is a tax deferral statute for essentially elderly poor. For people who've reached a certain age, whose property does not exceed a certain valuation, and whose household income is below a certain amount. And that law was adopted in 1996 and never amended. So the numbers are wildly out of date, but it would address the problem that is being perceived with people on fixed incomes, being foreclosed on.
Right.
And the pandemic is raising issues about how else to soften the system, because there's so many people out of work facing, challenges with their bills. I've been on a working committee chaired by the Coconino County Treasurer to try to address those issues. And I've pointed out to the people on the committee, well, this isn't the same as a mortgage foreclosure where you just missed your mortgage payments from the beginning of this year because of COVID.
Right.
Property tax liens are a problem that go back years.
Right.
It's a much more slow-moving process in Arizona. So somebody facing foreclosure this year is somebody who didn't pay their 2015 and subsequent property taxes. So it's, property tax area is not really a place to start with alleviating social problems, right? But there are examples in history, both from the Depression, where the redemption period was extended, or there were interest holidays or moratoria granted to delinquents. There were similar types of indulgences. I can't think of the right word for it, but accommodations is a better word, for returning servicemen after World War II, who might also have property tax problems. There are certain exemptions that were granted to servicemen from taxes, but the implementation was not very even. And so there are Supreme Court cases that have to do with the uncertainty around that whole process. So I would say all those things are probably on the table for the next legislative session. It's just that property tax revenue is still probably the single most important source of revenue at the local government level. And so they can't afford to give away too much of it through these accommodations, because sales tax, which is the other big source of revenue, is way depressed. And so property taxes being the stable source of revenue and hopefully predictable means that they're going to probably have to preserve it as much as they can in order to have any kind of workable county budgets. I'm talking with these county treasurers and some of the county managers. They know that the delinquency rates are going to be much higher for the 2019 tax year, and those 2019 taxes are the ones that go to auction in February of 2021. So we're probably going to see a bump up in the amount of tax liens available for purchase, depending on how recovery happens. They may never reach the 3-year mark, or they may. There was quite a big bump up after the 2008 fiscal crisis in the amount of delinquent taxes, which stayed around and had to be foreclosed in the normal tax lien foreclosure process, because the mortgage companies holding mortgage liens in those securitized pools on Wall Street that Michael Lewis made famous in his book, they didn't act to protect or enforce their liens. And so they were like force fields around blighted property, and the tax liens were like a sword that cut that Gordian knot. I'm mixing metaphors like crazy, sorry. but the tax liens were the tool for wiping all those mortgage encumbrances out and returning blighted properties to the stream of commerce. Otherwise, they would have just continued to drag neighborhoods down with them as they deteriorated, and they were being stripped of their copper, and they were being torn apart by the elements. So
got it. Interesting. Well, I sure hope you're right in that they won't change it too much. But one thing I've learned over the years is government doesn't always follow logic. It follows emotion, and so it'll be interesting to see how that plays out over the next year or so.
The safest admonition is always expect the unexpected.
Yes, good way to put it. Well, Mark, I immensely appreciate your knowledge and time today. I think everyone else that is listening will learn as much, if not more, than I did. And I certainly look forward to seeing you at NTLA, and we'll see if it happens in the spring. But I look forward to seeing you whenever the next one happens.
Hopefully they will resume. Anyway, It's a pleasure, and I hope it was worthwhile. Thanks a lot.
Thanks, Mark.
I'll see you.